Hey guys, hopefully everyone can hear me well. I'm going to walk you through Roe v. Wade, which is one of our first cases for the week. I didn't have any questions from any of my 3 classes on the discussion board where I talked about answering questions, so I'm just going to walk you through the case, and hopefully that will help you have a better understanding. So starting at the beginning of Roe, the court discusses that it's a sensitive and emotional topic. I think it's important that they do that because they acknowledge that there's opposing views, that they may have different views even among themselves as the judges, and that everyone has pretty strong feelings on the topic of abortion. They mention here, I want to say 4th paragraph down, our task is to resolve the issue of constitutional measurement free of emotion and predilection. So I think it's important that they try to do that. That's what you're always looking for in a court decision, but you will notice in many court decisions it is clear that that is not the case. Going down that first page, it discusses the Texas statute. So the Texas statute that was in question made it a crime to procure an abortion, defined, or to attempt one, except with respect to an abortion procured or attempted by medical advice for the purpose of saving the mother. So it didn't have any exception for her health. It didn't have any limitations within the time frame for the pregnancy. So anytime you attempted an abortion or a woman attempted to give herself an abortion for any reason other than to save her life, it was illegal in the state of Texas at that time. Then moving down, the court goes to discuss the facts. So there are 3 different sets of plaintiffs here. It mainly focuses on Jane Roe. So we'll talk about her first. She was an unwed woman who became pregnant, and she could not obtain an abortion in the state of Texas. She sued because she indicated that the law in place was unconstitutionally vague. It abridged her right of personal privacy, and that privacy was protected by the 1st, 4th, 5th, 9th, and 14th Amendments. There was another plaintiff who was Dr. Halford. He was a licensed physician and he performed abortions and had been arrested for violating that Texas statute on a couple of occasions. So he also joined this lawsuit. And then the 3rd plaintiffs were John and Mary Doe. Again, the Does are not their actual names, but they were the names that they used in the case. And Mrs. Doe indicated that because she had a medical condition, that her physician indicated that it would be dangerous for her to become pregnant. But they also indicated that they needed her to stop taking birth controls for a medical reason. And so she indicated that if she were to become pregnant, that she would want to terminate that pregnancy for her safety and her health. The court indicated that Jane Roe had a case that was both ripe and moot for discussion. They indicated that Mr. Halford had a justiciable controversy as well, but that the Does did not, because in order to bring, this is not something that you really needed to focus on, but just so you understand the case. In order to bring a case before a judge, it has to be ripe, it has to be pertinent at the time, and you have had to be harmed in some way. And because it was just something that might happen for the Does, they didn't have any real harm to discuss at this time. So their case was not brought to court. So it went forward with Roe and Halford. Roe was pregnant at the time. They discussed why it wasn't moot, because by the time it got to the Supreme Court, she obviously wasn't pregnant anymore. It takes forever to get anything to the Supreme Court. And they said that didn't terminate her right to go ahead and sue for that, even though she wasn't pregnant anymore and it wasn't something that she needed currently, because they indicated that if any pregnant woman were to bring any case, it probably wouldn't even get out of appeals by the time she had the baby, just because our judicial process moves pretty slow. So that didn't keep her from bringing a case. The next thing the court did, and you'll see this under Roman numeral 6, is that they went through and they discussed a lot of history of abortion in our country and other countries. They talked about ancient attitudes on abortion, the Hippocratic Oath. You notice this goes on for several pages. We're looking at 6.2 or 3. 6.3 is where the court first discusses the word quickening or quick, and that was the first recognizable sign of fetal movement. That had been a point for a lot of different laws in the past, in which before you felt that quick feeling where you could feel the fetus move, that was a time when abortion was allowed, and after that time it was not allowed. So they discussed that quite a bit. They continue to move into some British law and then get into a little bit of American law. And you can see under number 5 there, they mention that Connecticut is the first state to enact abortion legislation. I think one of the reasons that they went through so much history was because they didn't have a nationally decided case. They didn't have anything to look to. So they looked to other countries' laws. They looked to past laws of past states, just to kind of make sure that they had considered all the factors that were important and what other people thought about this particular subject. Moving along, when you hit number 7, they talk about the American Public Health Association in October of 1970 discussed some standards that they had adopted for abortion services. And looking through those, first, that it be rapid, simple abortion needs to be readily available everywhere. B, an important function of counseling would be to expedite that process, and that counseling should not delay a woman receiving an abortion. Third, psychiatric consultation should not be mandatory. It should be a case-by-case situation there. A wide range of individuals could qualify as counselors, and that contraception and sterilization should be discussed with every person receiving an abortion. They also discussed some of the life and health factors that were pertinent with respect to an abortion. The skill of the physician was obviously an important factor. The environment where the abortion was performed was an important factor. And probably the most important factor that they discussed was the duration of the pregnancy, as determined by uterine size and menstrual history, because as the pregnancy progresses, the danger of the procedure increases as well as the complications of the procedure, the length, the amount of skill the physician needs to have. So they thought that was a very important thing to be considered. Moving along, under 7, they discuss some reasons that abortion statutes have been enacted in states. First was to deter improper sexual acts. They quickly, Texas didn't propose that in this case. They quickly mentioned that is not an appropriate reason to restrict abortion in the states. Second was because abortion was dangerous. Now they go through a little history here and talk about the fact that it did used to be a more dangerous procedure. But you'll see in the second paragraph there, they say mortality rates for women undergoing early abortions, where the procedure is legal, appear to be as low or lower than the rates for normal childbirth. So while abortion may have been a bit more dangerous in the past, at this point in time, at least early in the pregnancy, it was not more dangerous than just a typical childbirth. So that kind of flew to the wayside. And again, that was not a reason that the state of Texas was proposing here. The third was the protection of prenatal life, which is the reason that Texas was advancing at this point in time. And they mention the pregnant mother herself is at stake, balanced against the life she carries with her. Should the interest of the embryo or fetus not prevail? Logically, of course, a legitimate state interest in this area need not stand or fall on the acceptance of belief that life begins at conception or at some other point prior to birth. So here, Texas had said it, that life begins at conception, and they're really saying whether or not you have to want to protect the fetus at some point or should be able to, we don't have to decide now when life begins, and we're not going to do that. Then they go through and they talk about the right to privacy. So Jane Roe had indicated that that was the reason, that one of the reasons that she felt that she should be able to obtain an abortion was because she was availed of some privacy rights that she had, and she listed a number of amendments. I think the court ultimately decided that they thought the 14th Amendment was the best for protecting those rights. But the first thing they say is the Constitution does not explicitly mention a right of privacy, and it doesn't. But they've recognized that a personal right of privacy does exist and is guaranteed within certain zones under the Constitution. So they preferred the 14th Amendment, said that it's broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Specific and direct harm medically diagnosable even early in pregnancy may be involved. And then they discuss a couple of reasons why a woman might want to terminate, and they think all of those reasons are valid. They said, she may have other kids, she may have had a forced situation for the pregnancy,